What if a company knows that a major corporate announcement is about to be approved, but investors remain completely unaware until after the decision is taken? What if a board meeting is scheduled to approve financial results, a buyback, a bonus issue, a fundraising proposal, or a major strategic transaction, and only a select few people know about it beforehand? Would that create an unfair advantage? Could insider trading risks increase? Could market integrity be compromised? Could investor confidence be damaged? And why has SEBI made it mandatory for listed companies to inform stock exchanges before certain board meetings are held? Is Regulation 29 merely an intimation requirement, or is it one of the most important transparency provisions protecting fairness in the securities market? Can a failure to give prior intimation result in regulatory action? Can stock exchanges impose penalties? Can governance concerns arise simply because a company missed a timeline by a few hours? Most importantly, how does Regulation 29 ensure equal access to information for all investors? Today, we are decoding one of the most practical and frequently used compliance provisions under the SEBI listing obligations and disclosure requirements regulations. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Regulation 29 is one of the most important disclosure provisions applicable to listed entities. Almost every listed company interacts with this regulation repeatedly throughout the year. Whenever significant matters are proposed to be considered by the board of directors, Regulation 29 often becomes relevant. Many professionals initially view the regulation as a routine stock exchange filing requirement. However, the real purpose behind Regulation 29 extends far beyond compliance. The regulation seeks to protect market fairness. It seeks to promote transparency. It seeks to reduce information asymmetry. It seeks to strengthen investor confidence. And most importantly, it seeks to ensure that material board decisions are not surrounded by secrecy. The legislative philosophy behind Regulation 29 is based upon a simple principle. All investors should have equal access to important information. No investor should receive an unfair informational advantage merely because a significant board meeting is about to occur. Before understanding the technical requirements of Regulation 29, we must appreciate the governance problem it seeks to address. Imagine a listed company planning to approve quarterly financial results. Management already knows whether profits have increased or declined. Senior executives may understand future business prospects. Board members may have access to confidential information. If market participants remain unaware that a critical board meeting is about to occur, opportunities for unfair information advantages may arise. SEBI therefore requires prior disclosure of specified board meetings. The regulation acts as an early warning mechanism for investors and the market. It informs stakeholders that significant matters are scheduled for consideration. This allows investors to make informed decisions and promotes transparency within the securities market. One of the most important applications of Regulation 29 relates to financial results. Financial results directly influence investor decisions. They affect share prices. They impact market expectations. They influence analyst recommendations. They affect valuation metrics. Consequently, SEBI requires prior intimation before board meetings where financial results are proposed to be considered. This ensures that the market receives advance notice of important corporate developments. The regulation also applies to several other significant corporate actions: fundraising proposals, buyback proposals, voluntary delisting proposals, bonus issues, alteration of capital structures, matters having substantial impact on investors. These decisions can significantly affect shareholder value. Therefore, prior transparency becomes essential. A practical governance concept underlying Regulation 29 is information symmetry. Information symmetry exists when all market participants have equal access to material information. Information asymmetry exists when certain persons possess important information unavailable to others. Regulation 29 attempts to reduce information asymmetry by ensuring timely communication to stock exchanges. This supports the broader objectives of fair and efficient markets. From a company secretary's perspective, Regulation 29 is one of the most operationally significant provisions within the LODR framework. Compliance requires careful planning. Board calendars must be monitored. Meeting agendas must be reviewed. Timelines must be calculated accurately. Stock exchange intimations must be prepared properly. Supporting documentation must be maintained. Errors in timing can result in compliance deficiencies. Consequently, the company secretary often plays a central role in ensuring adherence to Regulation 29. One common mistake observed in practice involves confusion regarding working days. The regulation prescribes advance intimation requirements measured in working days. Incorrect calculation frequently results in inadvertent violations. Therefore, compliance professionals must carefully evaluate exchange holidays, weekends, and applicable timelines before issuing notices. Another practical issue arises when agenda items change. A board meeting may initially be scheduled for one purpose and later expanded to include additional matters. Whenever such situations arise, Regulation 29 implications should be reviewed carefully. Failure to provide appropriate prior intimation for newly introduced matters may create compliance concerns. This highlights the importance of continuous coordination between management, legal teams, and secretarial departments. The regulation also interacts closely with the SEBI prohibition of insider trading framework. Whenever significant board meetings are scheduled, trading window restrictions often become relevant. Unpublished price sensitive information may exist. Designated persons may possess confidential information. The company secretary must therefore evaluate both LODR and PIT compliance simultaneously. This interconnected compliance framework strengthens market integrity. Consider a practical example. Suppose a company intends to recommend a buyback of shares. A buyback proposal may significantly influence market perception. Investors may view the proposal positively. Share prices may react. Because such matters have potential market impact, SEBI expects prior transparency. Regulation 29, therefore, requires advance communication to stock exchanges before the board considers the proposal. This demonstrates how the regulation promotes fairness. Another example involves quarterly financial results. Investors closely track earnings announcements. Institutional investors build investment models around financial performance. Analysts issue forecasts. Market expectations develop over time. Advance notice of the board meeting contributes to transparency and orderly dissemination of information. The regulation also contributes significantly to investor protection. Retail investors often lack direct access to management. They rely heavily on stock exchange disclosures. Regulation 29 helps ensure that important board meetings do not occur entirely outside public visibility. This strengthens confidence in listed entities and capital markets. From a secretarial audit perspective, Regulation 29 compliance is routinely examined. Auditors frequently verify stock exchange intimations, board meeting notices, timeline calculations, and supporting documentation. Any delay or omission may result in observations. Therefore, documentation becomes critical. Copies of intimations, acknowledgements from stock exchanges, board agendas, minutes of meetings, internal approval records, all should be maintained properly. Another important governance principle reflected in Regulation 29 is predictability. Capital markets function efficiently when information flows occur through structured and predictable mechanisms. Unexpected disclosures without proper advance notice can increase uncertainty. Regulation 29 promotes orderly information dissemination. This benefits investors, analysts, regulators, and listed entities alike. For advocates, chartered accountants, cost accountants, and company secretaries, understanding Regulation 29 is essential during due diligence exercises, compliance reviews, public offerings, corporate restructuring transactions, and governance audits. The regulation frequently becomes relevant during significant corporate actions. Failure to comply can lead to stock exchange fines, regulatory scrutiny, reputational concerns, and governance observations. A practical compliance approach should include maintaining a board meeting calendar, creating advanced compliance alerts, verifying timelines, reviewing agendas periodically, and ensuring coordination between all relevant departments. Technology based compliance tracking systems can also significantly reduce risk. The most important lesson from Regulation 29 is that transparency begins before the board meeting, not after it. Many professionals focus only on post meeting disclosures. Regulation 29 reminds us that investors also deserve advance visibility regarding significant corporate decisions that are about to be considered. That principle lies at the heart of modern securities regulation. Ultimately, Regulation 29 is much more than a procedural filing requirement. It is a transparency safeguard. It is a market integrity mechanism. It is an investor protection tool. It is a governance discipline. And it is one of the most important provisions ensuring that listed companies communicate significant board meeting matters openly, fairly, and in a timely manner to the market. That is why every company secretary, director, compliance officer, advocate, chartered accountant, investor, and governance professional must understand Regulation 29 thoroughly and apply it with precision in day to day compliance practice. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.